Recording. Good afternoon, everybody. Welcome to this afternoon's webinar from the British Romanian Chamber of Commerce. I'm Neil McGregor. I'm Vice Chair of the Chamber. And the saying, you can never have too many lawyers. I'm very pleased this afternoon to welcome two of my professional colleagues from NPR Partners who will be speaking to us about insolvency milestones. Our speakers today are Anca Baidsan and Dana Radulescu, and I'll pass over to Anca in just a moment. A couple of admin points to begin with. You've probably heard that we are recording this session, so if you have questions or want to take part, please bear that in mind. We're also live on Facebook, and we usually have a much bigger audience on Facebook than we have face-to-face. And if you have questions for our speakers, you will see, if you're on Zoom, at the bottom of the screen, there is a chat box, which I will put in a quick message here. You can see where it is. So if you have anything you want to ask in the course of the presentation, please type in there. If you're on Facebook, you won't have access to that. So please write your questions on the chat on Facebook, and my colleagues, Anna and Stefan, will see that and pass that on to our two speakers. So insolvency is something that is not necessarily a bad thing. And that may seem strange, but it means unblocking fiscal resources or financial resources. And that's why sometimes things are put into the wrong assets, and that stops the flow of money. I'm sure we'll hear more about that from our two speakers. So, Anca, thank you very much to Dana and you for speaking to us this afternoon. The floor is yours.
Thank you. Thank you for having us. Yes, indeed, the opening of the insolvency procedure will generate an automatic stay of the enforcement procedures and also the claims aiming to obtain the recovering of debt. The soon-to-be post-pandemic context, as well as the growing problems in the supply chains, especially in China, the world's leading exporter, as well as the very recent significant drop of the worldwide consumption level, I think all these are elements for the significant increase of insolvencies and bankruptcies. So we were thinking that setting out the insolvency milestones could be important for both debtors and creditors in order to create a strategy aiming the successful reorganization on one hand, and for the creditors in order to maximize the recovery process of their claims. So the first milestone in an insolvency proceeding is obviously the opening of the proceeding, which can be requested by the debtor or by one or more creditors. The decision of opening the insolvency procedure will set very important deadlines. One of the most important deadlines is submission for the statement of claim. All creditors have the obligation to submit the statement of claims except the employees. Following such submission, the judicial administrator will analyze the statements of claim and also the supporting documents of the same, and draft and publish within the insolvency bulletin the preliminary table of creditors. This would be the second milestone in the insolvency, which will set for the first time the structure of the debt pool of the debtor. Within 7 days' time following the publication of the preliminary table of creditors within the insolvency bulletin, the creditors which are unhappy with their claim registration are able to file a challenge against the preliminary table of creditors, which will be settled on the merits of the case by the syndic judge. And following the settlement by the syndic judge, the creditors have the possibility to file an appeal before the Court of Appeal. Also, the decision of the syndic judge opening the insolvency procedure will set the date of the first meeting of the creditors' assembly with an agenda already set by the law, namely the confirmation of the judicial administrator, which at the opening of the procedure is only provisionally appointed by the syndic judge, but this provisionally appointed judicial administrator has to be confirmed by the majority of the creditors, and also the fee of the judicial administrator and the appointment of the creditors committee, consisting of 3 or 5 members, depending on the total value of the pool debt and the complexity of the procedure. Usually, a creditors committee of 5 members is preferred. At the same time, with the settlement of the challenges submitted by the creditors against the preliminary table, an authorized appraiser will perform the valuation of the assets of the debtor. The valuation expert will be appointed by the members of the creditors committee and has to be authorized by the Ministry of Justice. And following the settlement of the challenges against the preliminary table of creditors, as well the completion of the valuation report, the judicial administrator will draft and will publish within the insolvency bulletin the final table of creditors, which will set for the voting of the reorganization plan the structure of the pool debt, which is usually comprised of the secured claims category, the fiscal claims category, the salary claims category, indispensable claims such as suppliers, and of course, unsecured claims. Within 30 days' time, following the publication of the final table of creditors, the debtor, the judicial administrator, or a creditor owning a claim of at least 30% of the total pool debt has the right to submit the reorganization plan to the file. Following the submission of the reorganization plan to the file before the tribunal, the judicial administrator will publish an announcement regarding such submission in 5 days within the insolvency bulletin, which will also set the date of the meeting of the creditors' assembly, having as only point on the agenda the approval of the reorganization plan. And now my colleague Dana will talk about the milestones starting with the reorganization period.
Yes, indeed, as Neil was pointing out at the beginning of our discussion, insolvency may not be such a bad thing. It depends, of course, of the circumstances, and it's not a good thing as a matter of principle to face financial difficulties or be in distress for any reason whatsoever. But it can also be a chance to restructure your activity, to rethink your business model, to adapt your strategies and your business thinking to the new realities of the market. And from this perspective, of course, in addition to what my colleague Anka was pointing out, like the automatic stay off of any enforcement against the debtor, would be one of the reasons for which insolvency is not a thing that should be disregarded by should be disregarded per se by companies facing these difficulties, let's say, at the moment. It is important, however, to understand that this is a complex process, that it requires a certain amount of transparency and publicity of the process, because all the acts and communications and judicial proceedings are the conclusions and the resolutions and so on are published in the official insolvency bulletin, and that offers a certain exposure to the company facing difficulties, because anybody can have access to such insolvency bulletin. And it is also a collective procedure. I mean, there are could be lots of creditors, and such creditors may sometimes have different interests and different views on what should be done with the debtor estate, and that could create, let's say, not necessarily conflicts, but let's say different opinions during the insolvency. And this could lead at certain point to some time-consuming and maybe resources consuming process, in the sense that there might be challenges before the court. The procedure may take longer than expected by the debtor at the beginning, and all these risks should be considered by a company potentially contemplating the possibility of opening an insolvency. Another point that is important in our view, and based on our previous experience, it is important to consider before filing for an insolvency, is that any debtor facing difficulties does not stand any chance if there is no minimal support from its creditors. I mean, in other words, if you have a pool of creditors that are totally hostile and that they do not want to support any restructuring, any reorganization of the activity, and are not willing to accept a certain postponement of the satisfaction of their receivables, or even haircuts, because maybe postponement is more acceptable than accepting haircuts, then the real chances of the debtor to go through insolvency and close the procedure successfully at the end are significantly decreasing. That is why before deciding to go into this procedure, it is important to have, let's say, a fair and honest analysis of the situation from an internal perspective, and maybe also with the help of a legal consultant and a financial consultant, to see what can be done in the future, if there is in which ways the need for restructuring and rethinking of the activity should be directed, on one hand, and on the other hand, to clearly understand and undertake the risk associated to this procedure, which were mainly the one that we pointed out earlier, in the sense that it is important to keep your relationship with the creditors as close as possible, at least with the major important creditors, and obtain their support in this endeavor, because otherwise it will be very difficult to be successful. And I was pointing all this out because a reorganization plan is basically one of the key milestones of any insolvency, because after all the, let's say, efforts are done to settle the pool of debt, to settle in the judicial receiver, to impose a certain course of action to the procedure, it comes to a moment when the debtor should provide to its creditors a plan for restructuring, a plan how the debtor sees it can recover in the future. And this reorganization plan is therefore an important step. As Anca was pointing out, a reorganization plan may not only be proposed by a debtor, but also by one of its creditors holding at least 20% of the total pool debt, or by the judicial administrator, the judicial receiver. And there is a time frame within which this reorganization plan must be submitted, which is pretty tight I mean, it's within 30 days from the publication of the final table of receivables. That's why it's important to have a clear view on the main, let's say, at least the directions of the reorganization way before this moment of publication of the final table of receivables, in order to be able within these 30 days to come up with a plan that can be submitted to vote to the creditors. Okay, in certain exceptional circumstances, prolongation of another 30 days or so can be obtained from the syndic judge. But the rule is that within these 30 days, you as debtor, you should come up with a reorganization plan. This reorganization plan is and should be viewed as a complex document in the sense that on one hand, it should contain an analysis of the current situation of the company from an economic and financial perspective, and also an outline of the main future development directions for the company, as well as the most important chapter being the payment schedule of the creditors' receivables. As regards the main future directions of development, the law offers, we would say, a sufficiently comfortable room for being creative in the sense that there are several methods that you can follow for this reorganization, and it can also entail a corporate reorganization, let's say operational reorganization, total change of management structure, of operational flows. Also, it allows for a debt into equity conversion, assuming that I don't know, one of the creditors of the debtor are holding a significant amount of debt and might be interested, for example, in taking part of the debtor business and contributing to a future development. The law allows you to do that. The only exception is with respect to the budgetary claims. The fiscal receivables cannot be converted into shares of the debtor, so that's not an option. It also gives you the possibility, the law, to sell the assets that are not essential for the company activities, that may have not contributed in the past to the revenues of the company. As Neil was pointing out at the beginning, that could have been, let's say, not very inspired management decisions at certain point, the acquisition of those assets. It gives you the possibility, of course, to enter into new contracts or partially propose the transfer of part of certain line of business, for example, just selling not only assets but also selling some line of business, assuming that the debtor is active on several lines of business. Via the reorganization plan, the debtor can propose to these creditors to sell a line of business and keep the other one, let's say less profitable one. So all these methods, if are well thought and well analyzed before, can be combined in a way that could be successful for the debtor. Of course, it is important to have, in our view at least, and based on our previous experience, it is important for the debtor to have, let's say, experienced consultants that can be of real use in terms of how to rethink your strategy and how to rethink your business. As regards the schedule of payments, because I was mentioning at certain point the schedule of payments, and this as being the, let's say, tipping point of any reorganization plan. To be honest, at the end of the day, irrespective of how complex and let's say substantiated and interesting a reorganization plan may look like, because the debtor vision is interesting. At the end of the day, for the creditors, it comes up to when and how much they will satisfy the receivables. So the payment schedule in a reorganization plan is the one that I think in most of the cases is the first everybody looks at before expressing any views on that reorganization plan. The law allows the debtor to propose haircuts to the creditor's receivables. However, such haircuts must be well substantiated in the sense that the reorganization plan also contains an analysis insolvency versus bankruptcy, and this is a requirement of the law. So you cannot draft a reorganization plan just simply saying, look, if I can cut my debt at 50%, I'm just giving an example, then I will be able to recover and to pay the rest of the 50%. It doesn't work like that. The debtor should make an analysis based on, of course, financial data and data regarding the market, the type of business, market evolution, and so on, to show how would this potential haircut impact less the creditor than the event in which the company goes to bankruptcy. And when the company goes to bankruptcy, basically, and we will come back to that, to the categories of receivables. When the company goes to bankruptcy, only, let's say, the most preferred creditors, like the secured creditors, might have a chance to recover part of their receivables because they are secured. And but not all secured creditors, because mostly the creditors secured with movable or immovable mortgages, because over assets that can preserve at least a certain value. So for the other creditors that are not secured creditors, generally speaking, the bankruptcy option is not an option, because the bankruptcy does not give them any chance to recover any amount of their receivable. So this is the bankruptcy scenario versus an insolvency scenario, reorganization scenario, actually, whereby instead of getting 0 out of something, you are getting a certain percent. In most of the cases, that would make, let's say, a normal creditor to think that, okay, let's give a chance to this debtor, because at least I'll have a chance to get a certain percentage of my receivables instead of getting nothing. On the other side, it is also important to make sure that the business, even if the debtor is applying all these haircuts, is, let's say, solid enough, sound enough to resist on the market for the period of the reorganization, to still be competitive, and to not accumulate other debts, because the historical debts are stayed, let's say. I mean, you cannot enforce those debts against the debtor, but the activity continues. So there are other debts that are accumulating during the insolvency. And it is also important to manage in the context these debts that are accumulating it, because otherwise you will be facing the same a risk of not being able to pay your creditors at the end of the reorganization plan. Of course, an aspect that maybe nobody can really control and predict is the effect of time. And as we all know, time can work for you or against you. And that's a matter of, I don't know, maybe a matter of chance or a matter of, because sometimes when you have, even if at the beginning of the opening of the insolvency proceeding, the market is unstable, the market doesn't show many perspective for the activity of that debtor, so things could look bad, and the reorganization plan consequently may not look so bright and brilliant, and the debtor may not be able to satisfy the receivables 100%. Things may improve during time, because the reorganization plan is for 3 years according to the law, maybe for up to 3 years. It can be prolonged once with 1 year, up to 1 year. And for during the pandemic, the debtors also had the possibility to prolong the reorganization plan for up to 5 years, but that was for the pandemic reasoning. But again, during this, let's say, maximum period allowed by the law, 4 years, many things can happen, and this is an aspect that can play both in favor or against the debtor. But the important thing is to try to use that resource, which is the time, to play in your favor. That is why what we were trying to say here is that maybe even if things do not look good at the beginning, they might become better over time, and therefore at the beginning, the debtor may be more optimistic in the percentage of the satisfaction of the receivables. Let's say aiming to 100%, which is of course the percentage that is perfect for everybody involved, and potentially decrease this percentage during the implementation of the reorganization if needed. I mean, what I'm trying to say here is that maybe a debtor should consider the possibility not to apply a haircut from the very beginning, but consider a bit the possibilities and how things are evolving during the reorganization period, and maybe apply a haircut towards the end of the period if needed, to the extent needed. And of course, if it is substantiated, because that's an important thing, and it is of the essence. Any haircut needs to be substantiated. I mean, it needs to be imposed by the objective factors regarding the financial inability of the debtor to pay more, not by any other subjective reasons. So why we are saying this is that as mentioned at the beginning, it is important for a debtor to have the support of its creditors, and the creditors needs to trust the debtor, that the debtor is committed to reinvent its business, to let's say give a new, fresh air to that business, and put it on a new perspective in order to be able to pay the receivables. And if in certain cases, if the creditors see that the debtor was trying actually to achieve that during a certain period of time, but it was not achievable because of objective factors like I don't know, the market, mostly the market, because this is the most let's say important influencer of the situation of a debtor. depending on the nature of the business, but in most of the cases, this is the most important one. Seeing that the debtor is committed and tried to recover would give that creditor more comfort in, let's say, endorsing and voting in favor of a potential extension of the reorganization period, or a potential rescheduling of the payments in the initial schedule and so on. Because the reorganization plan, once submitted to the court, it is to be voted by the creditors, and once voted, it becomes, let's say, enforceable, binding on the debtor. But in the same time, it can be amended during the insolvency proceedings, and there is no limit as regards the number of amendments. The important thing is that the amendments are justified by objective reasons, and the amendments at the end of the day to be accepted and voted by the creditors. In this respect, with the vote of the creditors, it is important to know and understand as a debtor, in our view, that the reorganization plan is to be voted with a double majority, a majority in number of the categories, and we can go back to that slide with the categories that Anca was presenting before. So, assuming it's not mandatory, of course, to have all categories in an insolvency proceeding, because it depends on the nature of the business and the nature of the debt, actually. But you can have all 5 categories of creditors: secured fiscal claims, salary claims, essential creditors. This is what we consider as being in the indispensable claims category, and unsecured claims category. So once you have, I'm giving this example because it will be easier to understand than just saying that majority number of the categories and majority in terms of value, at least 30% of the total pool debt. So what we are saying by majority number of the categories means that, assuming you have 5 categories, you need a vote of 3 categories out of 5. That would be a majority number. And within a category, majority means the vote, the favorable vote, of course, of the creditor or creditors holding the majority in value within that category. So the reorganization plan must be voted by a majority number of the categories, and however, those voting categories in favor of the plan should represent at least 30% of the total value of the pool debt. Once the reorganization plan is voted by the creditors, the judicial administrator requests to the syndic judge to confirm such reorganization plan. The syndic judge, if the plan follows the requirements of the law, I mean, it contains the analysis, the insolvency versus bankruptcy that we were mentioning before, the analysis of the situation of the debtor, the forecast of revenues, the payment schedule, the methods for the reorganization, I mean, corporate restructuring or operational restructuring and so on, or sale of assets or any combination. The syndic judge normally confirmed the reorganization plan, and once confirmed, the reorganization plan basically becomes binding on the debtor, and the debtor must comply with the payment schedule undertaking under the reorganization plan. It is also important to understand as debtor that complying with the payment schedule in the reorganization plan is an important aspect that would make the creditors trust the debtor's ability to recover and satisfy the receivables. Because if there are, let's say, major delays, that could create the impression or the concern in the creditor's mind that the debtor is not able to fulfill its obligations, and such creditors, or some of them, may even file for bankruptcy because the law gives them such possibility. And this is another thing that we wanted to point out, that non-compliance with the payment schedule entitles the creditors to file for bankruptcy. As we were mentioning, again, the reorganization plan is not a definitive document for the entire procedure. It can be amended in any number of occasions that the debtor considers appropriate, provided, of course, that there is substance in that, and provided, of course, that such amendments are approved by the creditors. The amendments are to be approved with the same rules of majorities. I mean, a majority number of categories and at least 30% of the total value of the debt. If the reorganization plan is successful, and based on our experience, we've seen such cases, then the debtor can of course request the closing of the insolvency proceedings at the end of the reorganization, and it will be a successful closing once the procedure is closed, basically, and assuming that there have been haircuts through the reorganization plan. When the reorganization plan is approved, the total value of the debtor's debts toward its creditors will need to be adjusted to reflect the situation in the reorganization plan. And for the difference, the debtor will be basically released. And of course, the debtor can continue its activity following successful closure of the proceedings. And that would be, of course, a very happy end of the story. But again, this is the only thing we would like to add before starting the Q&A question session. Would be it is important we somehow pointed out the major aspects that a debtor should have in mind, because a debtor before facing before filing for an insolvency or while facing some difficulties. But as said at the beginning, it's very important, and the success is much conditioned in our view on the creditors supporting the debtor in its efforts to restructure and reorganize the activity. But in the same time, in the debtor respecting its undertakings under the reorganization plan and trying to understand and protect, let's say, the creditors in the sense that everything should be considered as a cooperation. We are trying, both the debtor and the creditors, they together are trying to find maybe not best way, but let's say most efficient ways to overcome a difficult situation at certain point that has consequences not only on the debtor itself, which faces insolvency, but also on its creditors.
I see two questions in the chat. When will Romania adopt the EU liquidation and bankruptcy framework? Near future, everybody is asking the same question. And what is the experience with the acceptability of haircuts, including fiscal. Well, the fiscal creditors is very unfriendly every time it gets a haircut. I've seen very few insolvency proceedings with 100% recovery of all claims. However, the fiscal creditor is supporting, from what I've seen, only if on one hand gets 100% recovery of the budgetary claims, and on the other hand, if he gets his outstanding debts accrued during the insolvency procedure by carrying out the core business on time. There are two very, very tough conditions to cover 100% and also pay on time all outstanding debts during insolvency, to pay all taxes on time. So usually the fiscal creditor is not very supportive of the debtor.
Yes, but true, but it's also a matter of context. I mean, the fiscal creditor is there to try to protect the fiscal claims and the budget, the state budget. So from this perspective, some may think that this approach is reasonable or justifiable. Or again, the important thing also for in our view, at least for a fiscal for a budgetary creditor, is to make sure that once the debtor seems to have real chances to recover, instead of pushing to bankruptcy, to be not, let's say, if you cannot be helpful, let's say, at least not to try to push very much on enforcement proceedings or things like that, that would actually reduce the chances of that debtor to recover, and basically at the end of the day, the chances for that debtor to continue to pay taxes to the state budget. It's true that from our experience, at least, unless there is 100% satisfaction degree of the receivables, the budgetary creditors are not voting in favor of reorganization plan. But again, it's a matter of approach, it's a matter of policy, and we do not necessarily comment the reasoning of such policy, because it's not our our ability to do so. But yes, because to answer your question from a practical perspective, in most of the cases, there will not be an affirmative vote of a budgetary creditor on a reorganization plan that gives the budget a haircut.
Good outcomes of insolvency. Yes, I've seen insolvencies with successful reorganization with 100% recovery of all categories of claim. Should we say names?
No. Yes, there are cases of successful insolvency. I mean, it's just not, it's not only a myth that, okay, insolvency can be successful. It's true that the percentage of successful insolvency is not that high as we would like to see. But that's not, let's say, necessarily the fault of, if I may say so, of the legislation or of the debtors. It's a combination of factors. As we were saying, time plays an important role in this, and time can play a role both in favor or against. So sometimes things are happening during the reorganization, during the insolvency proceeding, during the reorganization procedure, that that, let's say, decrease the chances of the debtor to recover, and at the end of the day, the reorganization falls down into bankruptcy. But I mean, this is true; it can happen, but there are also cases of successful insolvencies.
So provided we have the approval of the categories excluding fiscal and at least 20% overall, we can have budgetary haircuts. Absolutely. Let's go back to the 5 categories in our example on the slide here. So assuming we have an insolvency procedure with all these, going back, with all these 5 categories, if we have at least 3 categories accepted in the plan, let's say, just as an example, that we have the secured claims approving, the salary claims, and the unsecured claims, we can apply a haircut to the fiscal claims category, assuming, of course, that the budgetary, that the fiscal creditor will never approve such reorganization plan applying for haircuts. But yes, it's possible as long as we have the majority of the categories. In this case, if we'd have the secured, salary, and unsecured, let's say, and also over 30% of the total value of the pool debt accepting the plan. So yes, it is possible.
Yes, indeed. I think one aspect that we should mention is that as long as, for the sake of the argument and to respond to the questions, if you are applying a haircut to the budgetary category, to the fiscal claims, you cannot give 100% to the next categories. Yes. So there can be, because this is the order of priority, let's say, and if you apply haircuts to the first category, for example, to the secured claims, just theoretically speaking, then you cannot give to the fiscal claims 100% and so on to the next categories. So once you apply a haircut, you should make sure that the following categories in the order of priority are not getting more. And it is also another important test, as we were saying, to make a clear analysis and to be very, let's say, obvious and clear to all creditors, the scenario and the analysis of the insolvency scenario versus bankruptcy scenario. Because if it results from the financial economic data, market analysis, that such haircuts are not substantiated, then there is basically no basis for that. I mean, this is an important point, and we stressed this out in our presentation. It has to be a substantiated haircut. I mean, it has to be reflected in the economic reality of the debtor. It's not let's say, wish thinking or nice to have, or it has to be something that it has to be there. I mean, and it has to be grounded and substantiated.
Also, can you give us an example of circumstance in which the deadline for the reorganization plan can be extended? Yes, for example, legislative amendments, very recent, which could influence the potential payment schedule.
I mean, if you mean, if you have in mind an extension beyond the 4 years, because the reorganization plan, it's theoretically initially for 3 years. It can be extended up to 4 years. And it has been that exceptional circumstances related to the pandemic, in which the debtor could have requested for an extension up to 5 years.
I understand this question a bit differently. I thought the question was a circumstance which would convince the syndic judge to extend the 30 days period deadline for the submission of the reorganization plan and not the implementation period.
Okay.
So
we have different understanding of the question, so we can answer both
ways.
Yeah. For example, if I don't know, the complexity of the case, maybe the short period between the opening of the moment of the opening of the insolvency and the moment of the final table of receivables, which did not give sufficient time to the debtor to analyze its situation and propose a grounded reorganization plan and a detailed and substantiated reorganization plan. That would be a reasoning. But again, this has to be the exception and not the rule. The rule is that the reorganization plan needs to be submitted within 30 days from the publication of the final table of receivables.
However, more often than not, I think the syndic judge usually grants such extension because if not bankruptcy. So let's wait for 30 more days.
Yes, indeed. But again, the extension is around another 30 days. It's not like another
a
6
year
months
or yes. If there are any other questions.
Perhaps I can just ask one final question. Do you agree with my comment at the beginning of the webinar that insolvency can be a good thing?
Yeah, totally. Actually, we've relied on this affirmation of yours, and we scratched our presentation around it. So yes, indeed, the insolvency can be a good thing.
Good heavens, 3 lawyers all agreeing. That's a remarkable thing.
Yeah. That must be something.
Yeah. Well, I can see we have, I think, 50 people with us on Facebook. So good to see you all. I hope you've enjoyed this afternoon's webinar. Ladies, thank you very much for a very interesting presentation on what might at first sight have seemed a very depressing subject to be talking about, but I think you've been able to express how that this can be an important business tool. I must go for a haircut at some point at this. So thank you very much indeed. And thank you to Anna and Stefan for putting this on for us today. Can I let people know that we have another event coming very shortly, and I will put up a link to that in the screen, and that is going to be about factoring solutions in export finance. And the link for that is going into the chat box now, and you should be able to see that. There we are. And so that will be coming up as an online event on the 15th of June, so not far away. Can I wish you all a very pleasant afternoon. To those of you who are going to the Queen's birthday party this evening, I look forward to seeing you there. And in the meantime,
thank you.
Certainly weather here to be enjoying a very good summer. Thank you, ladies. Thank you, Stefan. Thank you, Anna. And have a good afternoon, everybody.
Thank you.